All right, let's go on the record on cause number DC 2018633, Zatoun versus Elshamy. Counsel, make your appearances.
Good afternoon, Your Honor. It's Jonathan Scott, counsel for Jordan and Aaron Zatoun, the plaintiffs.
Good afternoon, Your Honor. Julie Pettit-Greason on behalf of Sam Elshamy, Dylan Elshamy, and Versailles Dallas, Inc.
All right, we're here on it says emergency motion, I guess, to set dates. Is that what what we're about here?
Yes, Your Honor. And before I get into the argument,
tell me what's...
Sure, I'll be happy to. The short answer, Your Honor, is we are 1 week away from the outside date under the parties' agreement to complete the statutory buyback. And my clients, I'll show you a slide and go over it with you, but my clients have done everything they can possibly do other than move out. They've tendered the deed, they've taken care of the title work, they've scheduled a closing, they have tendered the keys to the property to the title company, they have asked for an agreement to give them a few days to move out with their 16-month-old and 3-year-old. And we've had no cooperation whatsoever, Your Honor. In the meantime, we've asked that they wire the funds to the title company escrow officer, the remaining funds, and absolutely nothing is happening as far as we can tell on the part of the defendants. And so the parties made an agreement. We intend to move forward with it. We've performed 80% of what we're supposed to do as far as we can go. And the next step is for the defendants to send in the remaining balance to the title company and confirm the closing date, which the 45th day is next Monday, March 8th.
Isn't that usually, I'm not an expert on this, but isn't that usually done on the date of the closing, the wiring, or no?
No, well, here's the, can I respond, Your Honor?
Sure.
The difference here, Your Honor, is this is a statutory buyback. So the way the statute reads, which I've quoted in the motion, it's conditioned, the move out obligation and the tender of the deed on the part of the homeowner is conditioned on the contractor tendering the funds. And so we're not asking that the funds be released. What we're trying to do, and I'm sorry that we're even having to be in front of the court, but we tried to work this out starting a month ago to get some logic and scheduling here so that we could move this forward in effectuating the settlement in a rational manner. And
do you guys have a closing date or not? Or is there a closing date set?
Well, Your Honor, we set it for March 8th at 11 o'clock and asked the Elshamy's counsel to confirm at Trinity Title that they would attend and they would tender performance. And the issue, Your Honor, is that we previously had problems, even when Your Honor made an order, in getting payments from the Elshamy's. So, Your Honor, on that Exhibit 117 during the trial that they produced in the middle of the trial for the first time after 2 years of litigation, Your Honor ordered them to pay 2 hours of attorney's fees and our experts, and they would overnight that check to my office. And what happened is, according to the post office tracking, they put an incomplete address on the envelope going to my office. And I've asked counsel to resolve this by depositing the check in the registry of the court so we don't have another issue about a check being lost in the mail. And this is only a $2,000 item, Your Honor. And so my clients accepted this settlement. They have great financial hardship. And for them to go and hire a mover and move out and then find out afterward that the funds are not forthcoming is problematic. And so the title company, in any other circumstance, just in a normal real estate closing, they have to have cleared funds in order to close the transaction. So they've run this all the way to the 11th hour with no cooperation. And we have done everything that we can possibly do. And all we're looking for, Your Honor, is to have, based on the history here, these defendants need to understand that there are consequences if they don't perform the statutory buyout on time. And so far, we are getting absolutely No cooperation. I'd like to, before I do that, Your Honor, I want to just reconfirm something. The statutory buyback offer was dated January 5th, and in the offer itself, it had a confidentiality provision. After that document was drafted and before it was accepted, that was, as Your Honor will recall, shown in open court to multiple witnesses by Ms. Pettit-Greason. And so last time we had a hearing before Your Honor, Mr. Ackles said, I want to make sure, and I likewise want to make sure, that they are not going to say that by us talking about this settlement agreement with Your Honor, that we are somehow, violating the confidentiality provision as to the terms. Our view of it is there is no confidentiality agreement or provision because they've disclosed it in open court prior to its acceptance. And counsel
All right,
previously.
so let me hear from Ms. Pettit at this point, or Ms. Pettit-Greason.
Sure. Your Honor, there are quite a few different points covered, so I'll try to be brief and cover each. First, as Your Honor recalls, the last time that we all communicated, it was on a phone call with Your Honor, in which Your Honor indicated to all of us that you expected there would be a normal contract pursuant to the Texas Real Estate Commission, and you said multiple times this should be a normal closing. So as soon as that phone call was over, from that point forward, Mr. Scott refused to do a normal closing. So we still do not have a contract promulgated by the Texas Real Estate Commission because Mr. Scott refuses to do so, even though Your Honor made that pretty clear that that was your expectation. So we have no contract. Typically, a contract is what determines, the closing date and things of that nature. But even though he's refused to do a contract, that's fine. We're still operating as if this is in place. We have until next week to do a closing and pay the money. Mr. Scott constantly sends me demands that he wants to see a proof of funds. Well, that's not in the contract. There's nothing required. If my client doesn't pay and doesn't perform, we all know what rights and remedies Mr. Scott has at that point in time. That simply hasn't occurred. So as of right now, we have no contract, but there is a title policy, title commitment. My clients intend to comply just as we're required to do. We have missed no deadline.
Can I ask a question? Because he said
Sure.
something I'm not as 100% familiar with how this procedure works under RCLA or RCLA, RCLA. Is it required that as soon as the closing occurs, they have to move out immediately, or how does that work exactly under RCLA?
Sure. I am not aware that there's any additional time given to them. Obviously, we're going to be reasonable, but part of our offer was that they were required to move out at that time. But that kind of raises another issue that has come up, which is it's our belief that they don't live there and haven't lived there for some time. The offer was very specific that they were to leave the property in the as-is condition as of the date that we did the inspection. So as you recall, counsel went out to the property, I think after the first day of trial, and the property has to be in that as-is condition as of the date that we made the offer. Well, since that time, it appears that the windows have been boarded up, things have been broken into. We're not sure what happened with the pipes. You've asked for some sort of confirmation that it's still in the same condition it was when we saw it on the date of the offer. And Mr. Scott apparently is of the position that his client gets to continue to destroy the house and board up windows and break windows during this interim time period from when we made the offer until now, which simply, that doesn't make sense. The offer was very clear that it was as is on that particular date. The third issue I'd like to cover briefly is, this is just more of the same, but I have personally sent Mr. Scott 5 separate emails saying, I have your little check for the depositions that the court ordered in trial. Where would you like me to send it? We'll send a courier. I've sent personally 5 emails and he refuses. So he wants to tell Your Honor that we don't do it. I literally am holding the check. I have been and would love to give it to Mr. Scott because I'm tired of looking at it. But I can't get simple answers. So we don't have a check contract. I have his check. The windows have been busted and boarded up. We don't know what's happening with the pipes. If it gets to a point where he thinks we've breached, I think he can take that up with the court. If I get to a point where I think they've breached, we can take it up with the court. But there's simply, in my mind, nothing for the court to rule on at this moment.
I guess the only point I'd raise here, and I guess it depends on if the Zatoons are actually living there or not, is given the unusual nature of this, I'd like to see them have at least 2 weeks to move out after the closing date. Now, I do think you should be able to inspect it before the closing date to make sure that it's in good condition, but or not good condition at the same it's not in good condition, but the same condition it was prior to all this stuff happening. So I guess those would be the 2 points I would make, is I think you should have the right to and the reason I think there should be a 2-week delay is that I do think there is some chance your client may not close, and I don't want them to have to move out if they're living there and then be stuck, kind of mid, having to move out and then move back in or whatever it is. So those would be the 2 things I would suggest. Those are not rulings because I don't think I have the power to rule on this, but I do think those are 2 things I would suggest.
I'm open to those, Your Honor, and I think my client would be open to that as well. But it's something, again, I go back. We need a contract in place, and without one, Your Honor can say what you want, and I can volunteer on behalf of my client to happily give them time to move out. But I can almost assure you that Mr. Scott's not going to be willing to let us inspect it. He's not going to be willing to sign a contract.
So, Your Honor, I'll be happy to respond to that. First of all, I think your suggestion that the Zatoun should have time to move out after they see the funding and see that this is closed is reasonable, and we very much appreciate that. With regard to counsel's position, going back to as to now we need to put a second agreement on top of our settlement agreement. We did discuss this, Your Honor, and at the status conference on February 4th, because counsel indicated that she represented 30 some odd title companies, and no title company would go and open title on a statutory buyback. This is not a residential contractual sale. This is a statutory offer. And I had indicated, Your Honor, that we had located or determined that there were 2 title companies that indicated that they would do all of the title work and do everything that was required. And that's Trinity Title. We opened title with Trinity Title over a month ago. We asked the Versailles and or their counsel to be in touch with Trinity Title. My understanding is the very first time that there was any contact was on Friday, 2 days ago. So here we are 37 days into a 45-day statutory buyback. And counsel again wants to raise this issue about needing a second agreement where the title company, Your Honor, even though this was not a term of our agreement, has agreed that the settlement agreement that was signed in this case is the contract. And they are administering this transaction accordingly without superimposing a contract. We're going by the statute, Your Honor, and they have furthermore, Your Honor, because counsel had indicated all kinds of other concerns at the beginning. Perhaps the Zatoun speculation.
I guess what's the problem with doing a standard contract?
I don't know. We need one, Your Honor. The title company is telling us even today that we need an assignment of a contract because my client wants to put it in an entity and not their individual name, and we can't do that because we don't have a direct contract. It's super complicated not have a contract. There's no good reason not to have one.
Judge, there's a few good reasons not to. One is a standard residential real estate contract essentially rewrites the statute. And so if I can share screen, I'd like to show the court how simple and easy the statute is. This should not be this hard. The statute, we're talking about a statutory buyback. Can I share screen, Your Honor?
You can.
Okay. Let me just get this out of your way. Your Honor, can you see this paragraph right below where it says conditioned?
Mm-hmm.
This is the provision of the buyback statute that says what the parties need to do. And also, Your Honor, just for the record, I would point out that counsel's statements about the house is destroyed and it's boarded up, and To the contrary, Your Honor, since the time that they inspected it, and we don't agree that that's a point of reference because the language is without damage caused by the homeowner. And I'll represent to the court, my clients have not damaged the property since the statutory buyback was accepted.
Well, I don't know who busted off the windows, but someone did.
Well, again, Your Honor, we're going by.
I mean, I'm looking at this. I don't know that it says one way or the other that you wouldn't have a TREC contract. You can. I'm not as familiar with TREC contracts, I'm sure, as Ms. Pettit-Greason is, but I know my recollection is, I say my understanding, my recollection is that there are provisions you can write into it. Isn't that right? It's a standard form.
We can write into it, Your Honor, but the issue is.
Mr. Scott, I feel like this is really, I don't know why you're making such a big deal about this. I want this deal to work. And if Ms. Pettit-Greason says she needs a contract in order to get the financing, in order to get this deal done, I mean, I'm also perfectly happy to say, look, there was no deal here and we just start over, go back to trial. I don't really want to do that, but I think it's just like, I think it's perfectly reasonable for you guys to get an extra 2 weeks to move out. I also think it's perfectly reasonable that you would have a TREC contract because it's going to allow her to have more opportunities for financing. Am I wrong about that, Ms. Pettit-Greason?
Nope, that's exactly right.
Nothing in this provision says one way or the other that you can't have a TREC contract. And so if that's a deal killer, then let's kill the deal and let's go back to trial. Mr. Scott, is that, and I remember very specifically that Mr. Zatoun had absolutely no problem with the TREC contract, is my recollection.
Well, he said that they're used, but he's not the lawyer on this file, and I'm the one that has to respond. But Judge, let me just say something else. Again, Ms. Greason didn't answer the question. Can I show the settlement offer to the judge?
I've seen the settlement offer. It doesn't say anything one way or the other about a TREC contract, but every settlement I've ever seen, from mediation to Rule 11s, always have some finalized contract that finalizes the deal, and the TREC contract would be that. I really feel like you're putting in impediments that are unnecessary in this case and are for absolutely no good reason.
You're right.
And so I'm not really sure I don't feel that there's anything else I need to do at this point. I just want to convey what my thoughts are. I'm not going to force you to do a TREC contract. I'm not going to force her to agree to the 2 weeks. But I will say that I feel very strongly that if the reason this falls apart is because you refuse to do a TREC contract, and Ms. Pettit-Greason on the same token, if you refuse to give them a reasonable time to move out, the contract's blown, the deal is blown, and we'll go from there and we'll just finish the trial.
Honor, may I respond to one thing briefly, if I may share screen?
Sure.
I was still presenting, Your Honor, and I wanted to show Your Honor and I wasn't arguing about whether or not the settlement agreement talks about a TREC contract. I just wanted to make the point that this is not subject to any contingencies. Their own offer says they're going to pay the money within 45 days, not subject to financing, not subject to contingencies, not subject to anything. And that was drafted by their counsel. And that's the deal we accepted. And Your Honor,
Ms. Pettit-Greason.
Yeah, we have not 45 days has not come and passed. So if 45 days comes and passes and my client doesn't perform, we know what remedies there are. That I don't dispute that the settlement offer says what it says. And as far as I know, that will be complied with. I won't put it up on the screen actually now that I think about it, because I understand there are others in the courtroom, but the offer was very clear as far as what the move out date was by the Zatouns. And so that's not something that was just a little bit ambiguous in the settlement. That was crystal clear and was given a date certain. And so I don't mean to quibble with Your Honor at all. I understand Your Honor's position, but just to be clear, that was a very important term that was included in the settlement offer from day one.
Say that again, I'm sorry.
Sure. The actual move out date by the Zatoons was a very important term to my client and was included specifically in the offer. So that's not a term that was, not.
So what you're saying is the 2 weeks extra was specifically not in the agreement.
Yes,
and
Your
the
Honor.
track it's silent as the track.
Yes, Your Honor. That said, my clients have been reasonable, and I can assure Your Honor that we will continue to be reasonable. My main concern at this point, and again, it's the deadline hasn't come and passed, which is why I'm not technically raising it, but my concern is the condition of the property appears to be much different than what would be required under the settlement offer. So if we're back, my concern is that it'll be for that reason.
Wait, did Mr. Scott leave? I don't see him.
I just lost him too.
Well, I think we should probably stop. Mr. Mosley, what are you here for?
I'm here on a motion by the receiver to be released and disburse funds.
Okay, is the receiver here yet?
Yes, Your Honor. This is Howard Mark Spector.
I'm not sure what happened to Mr. Scott, so let's go ahead and take care. Yours should be quick, right?
Yes, Your Honor. It's completely agreed.
Okay. And have you provided us an order already?
I'm just waiting on Mr. Wilson to agree that I can sign his name, but I believe I will be getting that.
Okay. Let's go on the record on cause number DC. You ready, Tony?
Yes, sir.
DC 1919685, Roberson versus Carter. Counsel, make your appearances.
Mark Mosley for the plaintiff, Martha Roberson.
Howard Mark Spector. I'm the receiver.
And are we, I apologize, I noticed it's 1:58. Are you guys expecting Mr. Wilson to be here?
Your Honor, I actually have no idea.
Your Honor, I do not. He's agreed to everything. He and I have emailed back and forth. The Rule 11 agreement is clear, succinct. The order prepared by Mr. Spector follows that to the T. So there should be no problem.
If you guys don't mind just staying on until 2:10, just in case he shows up. But go ahead and make your report, Mr. Mosley.
Respect.
Or Mr. Spector, I'm sorry, Mr. Spector.
No problem, Judge. This is Howard Mark Spector. I'm the receiver for property located at 10435 Chelmsford Drive in Dallas. The court appointed me on December 8th. As I reported to the court in a subsequent sale hearing, the property is a single-family residence. It was unoccupied and uninsured at the time of my appointment. Accordingly, I contacted a number of purchasers who I believed would close on this kind of sale quickly because they're investors in similar property. I garnered a bid for $65,250 from one party. At the time of the sale hearing, that was the highest and best bid that I had received. That was also coupled with an immediate close, which was again necessitated by the fact that it was vacant and uninsured. After payment of property taxes and other related closing costs, non-inclusive of any compensation to me, the net sale proceeds were $57,442.95, which is the amount that I currently hold. The receivership order contemplated that I would be paid $250 an hour plus reimbursement of actual out-of-pocket expenses. I devoted 13 and a half hours to selling the property and closing the sale, as well as writing my final report. I incurred $62.66 in expenses. Accordingly, I'm asking for the court to award compensation of $3,437.66 and to refund my bond. That will leave the net proceeds of sale at $54,005.29, which the parties have agreed to split between them in accordance with a existing settlement agreement. That settlement agreement provides for $35,000 to be paid to Mr. Mosley and his client, and the balance to be paid to Mr. Wilson's client. And I've provided both of them an agreed order that recites that and directs me to make checks out to them, which will dispose of all of the remaining proceeds and discharge my responsibilities to the property or the parties.
Mr. Mosley, do you have any opposition to this report?
No, Your Honor.
All right, the court will enter findings consistent with the report. If Mr. Spector, if you could go ahead and email my court coordinator as well as e-filing the order once you get it prepared. Also, if you guys wouldn't mind staying on the Zoom call for the next 8 minutes until 2:10, just in case Mr. Wilson shows up. Is there anything else we need? I'm so sorry, Mr. Spector, what did you say?
No, I'll be happy to. That's fine.
Okay. And Mr. Mosley, if you could also stay on as well. You can turn off your camera, but just in case he shows up. Anything else we need to discuss today, guys?
No, Judge.
No, Judge.
All right. Thank you so much, guys. Thank you for your service again, Mr. Spector. And we will take it from here. When do you think you can get us that order, Mr. Spector?
Oh, I'll have it to you within the hour, Judge.
Okay. Perfect. Just email Rhonda and make sure you get it e-filed. Thank you so much. Judge. And you guys are excused pending Mr. Wilson showing up. I see there's someone here, it looks like named David that showed up, or okay, I guess he fell off the call. All right, so we're back to the Zatoons versus Elshamys. Mr. Scott fell off the Zoom call, and so we took care of another hearing while he was off the Zoom call. I think I don't know exactly what we're going to do today, but I guess at this point, I don't really see the need to do anything. I'd urge Ms. Pettit for you to try to close and to take into account that giving them an extra 2 weeks. And Mr. Scott, I would strongly urge you to do a track contract on this. Anything else we need to talk about, guys?
Judge, I just want to tell you, we tried. So after the last court setting, the lawyers went back and forth with different drafts, and I told them that it was not yet approved by my client. And my client is fearful because he was the real estate broker for the Elshamys or for Versailles and has seen this over and over again, in which they sign agreements and then they use these provisions in a track contract to not perform. And so, Your Honor, if Ms. Pettit, and what I'm talking about, Your Honor, is all kinds of contingencies that are not in our settlement agreement. And so Ms. Pettit sent me her proposed version of a track contract. And I asked her, because she's more experienced with real estate transactions than I am, to please identify any provisions that they checked off the box to make a requirement that was not within the four corners of the settlement agreement. And she wouldn't answer me or acknowledge that.
Let me make sure I understood what happened here, Ms. Pettit-Greason. So did you not use this? And again, you're more experienced than anyone here on this call, I'm sure, about this issue. But the way I've seen track contracts is that you check off things. Did you use some kind of computer program so he couldn't see what you checked off?
Of course not, Your Honor.
Okay,
no,
so
I used a standard track contract.
So he should be able to tell what you checked and what you
Yes,
didn't check, and what you changed and what you didn't change from the standard track contract.
Yeah, and so that wasn't the issue, Your Honor. So what changes the substantive transaction in it, if you're talking about a residential real estate transaction, is what you check off or don't check off. So if you
can tell based on what she did, right? You can see what was checked and what wasn't checked.
Yes, Your Honor. But my client was not agreeable to. Here's, Your Honor, here's our issue. If she wants to prepare, we don't want any more delay. If she wants to prepare a track contract and tell me we're confirming the closing on Monday, we need you to come, we're going to have the money, and we're going to need your clients to sign this track contract at the closing, and we have the money and we're closing, we'll sign it because the settlement agreement has release provisions. So I'm not really concerned about what it says once we know for sure that we're closing the transaction. So if she wants to, she can draft whatever TREC contract, because at that point, when we show up at the closing, the contingencies are no longer an issue.
Ms. Pettigrew said, I don't think that he should have to close and sign that. His client shouldn't have to sign the settlement agreement, the TREC contract until the transaction is funded. That's how I've always seen it. Are you trying to do something different here? Oh, no, she left.
We lost her. Your Honor, when I was lost, the screen just froze and I had to reboot it.
That's weird.
I don't know what happened. And then Your Honor, it popped up a security warning in Zoom saying that there may be not a data breach, but some other kind of anomaly with the connection.
I'm not seeing anything here. Reagan, are you seeing anything, or Nancy? I don't know. I did hear about a mock trial tournament this weekend that had a huge Zoom meltdown, but I don't know if it was because of Zoom or not.
Mm-hmm.
I haven't had a whole lot of problems on Zoom
That's
since
good.
I started using it.
The only time I see it is up here with y'all.
Okay.
We don't do it at home.
Ms. French, are you there?
Yes, Your Honor.
Did you send that stuff over?
Yes, Your Honor, I did. And it turns out my paralegal actually got it filed around 1:05 this afternoon. So
Oh, good,
the
good.
news just hadn't trickled down to me yet. So because I got back whenever he was on lunch. So you know how it works.
Did you email my court coordinator, everything? Rhonda, can you go ask them to print that out? I'm sorry, Nancy, can you ask her?
She was gonna print it as soon as she got it in on her file.
I love how you said it trickled down from your paralegal. That's truly how most law firms work, I think. So
It is. Because I was sending him a bunch of messages and I was like, hey, the judge, like, this is what the judge is looking for, blah, blah. Sorry, I stole it from your desk. I made a copy. I hope that's cool. Hope I didn't mess anything up. And then he comes in, he's like, no, I already got it filed. It's like, about that. So, well, it's like, well, I'll try.
let's go back to, I guess, to the other hearing and figure out if we can.
Okay.
There's someone named David that keeps coming on and off of the call. Are we expecting a David?
Not on my side, Your Honor.
Ms. Pettigrew, or is David is that Mr. Ochiaga? No?
Oh. Hi. I'm not sure what happened on that.
Okay.
Can you hear me?
Yeah, kind of.
Okay.
All right, so I'm not sure what else I need to do today. So are you guys all good?
Well, Your Honor, you had asked a question before Ms. Greason got disconnected. And your question, as I understood it, was that it was your understanding that we shouldn't be required to sign a TREC contract until they funded the transaction. And you asked Ms. Greason, is she intending to do something different?
Yeah, so my question was that you're not asking him to sign the TREC contract before the closing.
Yes, Your Honor. The TREC contract is what governs everything leading up to the closing.
Okay, so that needs to be signed before the closing?
Yes.
Your Honor, the title company has already not only said that they don't require that, but furthermore, they have offered, and this was not part of our deal, they have offered to insure the title going into Versailles for the full purchase price that is stipulated there. So we went out, we got the title work done, and we've also, they have an offer for title insurance. So they're fully protected, and the title company is ready to close this thing next week on March 8th. And so counsel indicated something about assigning the contract to some third party. And we have no intention, Your Honor, I'm not trying to be difficult, but this is a settlement that was made by these defendants. So I'm not going to be agreeable to let them out of a statutory settlement because now at the last minute, they're talking about wanting to assign it. Now, if they want to do an assignment at the closing, as long as we get our money and everything closes and it's timely, we don't have any issue.
I think at this point, there's nothing I can do about this. If everything closes and it's all done, I hope that's what happens. Great. If it doesn't, you guys can blame each other and fight over it, and we can continue to have hearings on this. But I don't think at this point there's anything I can do that would be appropriate. I've just given my suggestions on how to move forward. So at this point, let's just try to get this closing done. I think, what is it going to be? Supposed to be next week? Let's hope it happens.
Yes, Your Honor.
And if there's a problem, we'll deal with it then. So good to see you guys, and you guys be safe, okay?
Thank you, Judge. Thanks. Bye-bye.
Thank you. Ms. French, are you there?
Yes, Your Honor, I'm here.
So we have the affidavit. Did you submit a proposed judgment as well?
My records indicate that one was filed along with everything else, but I am sending a copy of that to Rhonda right now.
Okay, go ahead and send. That might be easier. Max, can you go grab that from Rhonda? Reagan, you picked the better chair. You don't have to keep on getting up and.
I know she got the good side.
Yeah. All right, let's go on the record, Tony, on cause number DC 202321. Deverick Travis, is that how you say his name, Deverick?
As far as I know, that's how you say it.
Okay, versus Leonard McMorris. Counsel, make your appearance.
This is Amanda French, and I represent the plaintiff, Mr. Travis.
All right, we're here on a default judgment. You just submitted an affidavit of Deverick Travis. Do you wish to admit that as Exhibit 1?
Yes, Your Honor.
All right, make sure also that you email that to the court reporter as well. She'll go ahead and give you that. But I'll mark this as Exhibit 1. Okay, and then do you have any other exhibits you want to offer today? Do you have the medical records all proved up and everything?
Yes, Your Honor. So the medical records and affidavits were previously filed and should be on file with the court.
Do you wish that do you like me to take judicial notice of those?
Yes, Your Honor.
All right, let's go ahead and proceed.
All right. So, Your Honor, this case was filed on February 11th of 2020 in regards to a September 2nd of 2019 motor vehicle accident. Defendant McMorris was served on March 25th of 2020. The deadline for him to file an answer was April 20th of 2020. To date, an answer still has not been filed, and all the proper the citation and proof of service were both on file with the court for at least 10 days prior to filing. And I mean, other than that, the damages of plaintiff have been proven up virtually through the client's affidavit, which has been admitted as Exhibit 1. And plaintiff just requests that the court grant his motion for default judgment on liability and damages.
The court will grant judgment as requested, assuming any corresponds with this affidavit. And the court will take judicial notice again of the filed for the medical records and bills. I'll go ahead and grant you your judgment off the record, Tony. I would say that it would probably be helpful in case this is challenged to have just for future reference, Ms. French, to have a paragraph that goes through what the impairment is. There's nothing that I can see in here that talks about impairment. Maybe I'm missing it, but it talks about the pain, but doesn't talk about the impairment. So you may want to do that in the future, but okay. I'll go ahead and grant judgment as requested. Anything else, Ms. French?
I believe that is all. And for who else was I supposed to send an email to? I just want to make sure.
I'm sorry, make sure you send the exhibit to Tony. Tony, can you put the your email address in the chat?
Perfect. I will get that sent right over.
All right, and you're not asking, let me just ask before you get off, I don't see any evidence of future medical, is that correct?
The future medical would be in the, I just completely blanked, in the medical records. So there were referrals for future medical.
And how much, what was the estimate in there? Because it's not in the affidavit.
Oh, let me double check. I believe, according to the normal handling attorney, it says that the referrals are around 2,500 to 3,000 for future medical.
All right, I do 2,500 for future medicals. I'm just looking at your thing here. Okay, pass. Future pain. In future. Okay. Nancy, this is the final judgment. You give it to. All right, I've entered default judgment as requested.
Thank you, Your Honor.
Thank you. You have a good day.
Yes, sir, you too.
2 o'clock. We got that taken care of. Do we have everyone here in the Jackson v. Preston Tower Condominium Association case?
David Jackson's here, plaintiff.
Yes, Your Honor. I think everybody's here.
Okay. All right, let's go on the record on cause number DC 1913360, David Jackson versus Preston Tower Condominium Association. Counsel, make your appearance.
Your Honor, Chris Payne and Christina Alstrom on behalf of plaintiff David Jackson, and obviously as just announced, Mr. Jackson is also present.
And Your Honor, David Johnson on behalf of the defendants.
We're here on a status conference, is that correct?
Yes, Your Honor. We're following up from last Monday when we had the hearing on defendant's motion for contempt and motion for supplemental protection. You had asked the attorneys to get together, work on language for a supplemental protective order. I think we're pretty close on our language. However, it's my understanding from speaking with counsel for the plaintiff that Mr. Payne and Ms. Alstrom are intending to withdraw as counsel from Mr. Jackson. So we wanted to discuss that with the court, and as well, the court asked that Mr. Jackson be present for this conference to discuss the protective order as well.
Your Honor,
go ahead, Mr. Payne, I'm sorry.
I'm happy to address that. While we have communicated that it was our intention to withdraw, Mr. Jackson and I have had a discussion, and I think we are probably in agreement that at least at this time that will not be required. I also think that, as Mr. Johnson said, that we are pretty close in terms of agreeing on the terms of the order from last week's hearing. Mr. Jackson considers this to be something that is extremely important, so much so that having in the immediate past, including up to yesterday, he intended to run for one of 2 open seats on the board of directors at the condominium, and that posed some pretty obvious problems in terms of free speech and any attempt to prospectively limit it. Because he considers this important, he has agreed that he is not going to run for a spot on the board. He will also agree that there will not be any communications directly with any counsel, whether it's counsel in this case or counsel for the association. Any communications that need to occur with those counsel will come from our office. And if we are unable to work something out specifically with Mr. Jackson as to whether or not there's an issue, or if it's an issue that we're not completely comfortable with, then we will approach opposing counsel and try and work something out with them by mutual agreement. The same will hold true with respect to communications with the board of directors. That same series of steps is something that he's willing to agree to. With that, hopefully we can proceed forward with the case and not encounter any issues that we've had up to this point.
And Your Honor, to add to what Mr. Payne said, and as far as the withdrawal, that I'd spoken with Ms. Alstron an hour ago and said that I'm very glad to hear that they are staying on. The issue with Mr. Jackson's emails, obviously he shouldn't be communicating with me. I've received 5 more emails from him this week after our last hearing. That needs to stop. But the harassing emails to my client, if they are going to be vetted through Mr. Payne and Ms. Alstron, then I'll want something in the proposed order. I haven't seen the language yet on that, to where he will agree not to communicate directly with either the board of directors or the management company regarding any of the claims related to the litigation, and that any kind of communications need to go through his counsel. He continues to send these harassing emails. There was one sent on Thursday to all the residents of Preston Tower discussing this litigation, and also making a representation that the board was going to mandate vaccinations, and he was encouraging people not to get vaccinated. There were other emails that were sent to me, to other counsel for the defendant. These emails have to stop. They come every single day to my clients. And if Mr. Payne and Ms. Alstron are saying that they will vet the emails and determine whether they are in compliance or if they violate the protective order, I'm all in favor of that. I just need these emails to stop to my clients.
Well, Your Honor, if I can address one point that he just made, and that is that at least one of the emails was to the entire membership of the Homeowners Association. And any motion that has been presented to this court has been limited to communications with counsel and communications with the members of the board of directors. There's been no relief that has been sought with respect to communications to other members of the association. And candidly, I think the court expressed last week that there were some gray areas. That would be one that, to my way of thinking, would probably cross the line in terms of prospective limitations on free speech, and would ask the court that we try and craft whatever we can so that he's at least able to communicate with other members about concerns that involve the entire community. In this circumstance, there are some real concerns about the fact that, and candidly, Judge, this isn't our first rodeo with this homeowners association. We've had other lawsuits involving them, and it's Mr. Jackson's understanding that there are enormous costs associated with the way the association has been run in the past. There is an issue that directly affects him with respect to the cost associated with the roof repairs that need to be made. And there have been statements that have been floated out there that it's going to cost upwards of $600,000 or $700,000, and that can either be as a result of a special assessment or an increase in dues. Those are matters which are of concern to the entire community, and he ought to have the ability to voice his concerns and to articulate any suggestions or solutions that he might have that would be the benefit of everybody in the community.
So we kind of discussed this last week, and my recollection is that there was kind of some communications that I thought were perfectly okay. For example, and Mr. Jackson could communicate about the roof leaks or repairs to his unit to the board, which I think is perfectly okay. There's communications where he's talking about the lawsuit to the board. That is clearly not appropriate. That needs to go between counsel. And so if that's happened since then, that it concerns me if that's the case. There's probably gray areas in between that are a little bit harder to, this whole thing about the vaccine, I don't really know. Is that I don't think that's a subject of the litigation. So if he wants to tell everybody not to get the vaccine, he can. I don't think that it'd be appropriate for me to. I don't agree with him, but personally, but I do think that he has the right to say that if that's true and it's what he believes.
Your Honor, briefly, the only reason I referenced the vaccine email is he didn't just tell everybody in the homeowners association not to get the vaccine. He went on to discuss specifically this litigation, specifically
the discussion of this litigation is clearly inappropriate. And I will say this to you, Mr. Jackson. I used to work in this area of law a good bit involving homeowners and homeowner associations. You're not doing your attorneys any favors by sending these emails out about litigation. It's going to make it harder for them to represent you. It's going to make it harder for the court to resolve this. It's going to be harder for you. It doesn't do anyone any good for you to communicate. It's clearly inappropriate under the rules to be communicating with Mr. Johnson's clients about this litigation directly. That needs to go through counsel. And so if that is continuing to occur, it's just going to cause a lot more problems. As I've said to Mr. Johnson, there are certain things that you should be able to communicate with the board that have nothing to do with this litigation. I'm not trying to impinge upon your First Amendment rights. And if you want to talk about your views about the vaccine, that I believe would be part of your First Amendment rights. The concern I have is the discussion of this litigation, which should be between counsel. And even if you get rid of your counsel, you still need to communicate with Mr. Johnson about this, not his client. And so, do you understand that, Mr. Jackson?
I understand exactly what you're talking about, Judge. Mr. Johnson is totally incorrect on the vaccine deal. The email that went out specifically talked about the fact that I need to have use of the gym, and that the board of directors had insisted that in order to use the gym, you had to get a vaccine. That's what they floated. Okay. I've had COVID. I almost died from it. I'm under doctor supervision. I have immunities. They do not want me taking the vaccine. And I floated that out in an email to the association. It did not refer to our specific lawsuit. It referred to the fact that there is currently a lawsuit against the association right now by Mr. Gutman for records requests and for use of the pool. The association attorney has created a new waiver that if I signed that, I would have to give up my rights to my current lawsuit because it's a global waiver. The governing documents clearly state that we are at our own.
So you're jumping around here, but the waiver you're talking about was the waiver referenced in this email, or does anyone have a copy of this email so I can see it?
The email, the only reference to this lawsuit was that the board of directors, let me put this in simple terms. The board of directors are in constant violation of the bylaws and governing documents on a monthly basis. They have appointed Clayton Hearn, association attorney, to be the referee on every issue. I don't have to go into detail after consulting with Mr. Payne, but I have 8 pages of documents and situations where everything that Mr. Johnson has told you is factually incorrect. I have not been communicating directly with Mr. Johnson other than on 2 occasions, maybe 3, and we could talk about those later. And yes, I would concede to those, but everything else was him being copied on disputes that occurred between the members and myself with the board of directors that Clayton Hearn, the association attorney, was playing referee on. He's playing referee on everything. So you could basically take every email that was sent to Mr. Hearn asking him to get the board of directors to fly straight on all the things that they've done that are wrong. And again, I have 8 pages.
So let me just say this. If you're talking about this litigation, so if there's a waiver that you believe would waive your rights in this litigation, that is not something that should be communicated to the board directly by you.
Okay, I acknowledge that.
Well, I'm the judge. I get to talk, okay?
Yes.
So, but if it's something, Mr. Johnson, if he has some other issue with the board that isn't related to this litigation, he should be able to include you in that if you have been designated, if that's correct, that you've been designated as the referee. Nothing in my order requires, or nothing in my proposed suggested order requires him to not communicate with you on matters that are not related to this case. Does that make sense?
It does, Your Honor. And all communications by Mr. Jackson and me have been related to this litigation.
Okay, well, that shouldn't be happening.
And then as to, if I can screen share just for a second, Your Honor, let me show you just a portion of this email that he sent. And again, I agree completely on the whole First Amendment rights, that he has a right to communicate his opinions. However, getting into the litigation, all of these emails will start talking about one thing and then they'll go into the litigation. And that's what this email did. If you look, let's see if I can get to this. If you look at this email, it starts off talking about talking about the vaccine, and then goes on, and then down at the end of it, he dives into our litigation again, talking about the attorneys, the board of directors, all of his requests. Then this is evidenced by the report in a member's lawsuit for $500,000. That's his lawsuit against the association for 2 major water claims, 1.5 years apart, for the board of directors' absolute refusal to. This is about our lawsuit. And this is communicated to the entire homeowners association, which includes the board members. They're not only board members, but they are members of the homeowners association. This is where we have a problem. And as to his communications directly with me.
Let me look at this. Give me 1 second. So the members' lawsuit for $500,000 against the association for 2 water claims, 1.5 years apart for the board of directors' absolute refusal. I'm not sure if I understand what this is. So that is this lawsuit, I assume?
Yes, Your Honor.
And a $200,000 an annual increase in ICI salaries.
Yeah.
And then the board paid off a member 2 years ago to the tune of $170,000. The board still refused to fix the roof after selling with this member on the penthouse floor.
The point of this, Your Honor, is that this is all going toward this lawsuit. And again, this is just one email. There are literally hundreds of emails that are being sent. Mr. Jackson sent an email to me at 1 o'clock in the morning on Saturday night, talking about this hearing, this litigation. This is what we are dealing with, Judge, and that's what we're trying to stop. I'm not trying to take away his First Amendment rights. I'm not trying to take away his right to discuss claims with his right to talk about the property with the management company, but he cannot be discussing this litigation with my clients. That's what the judge's previous orders.
Judge, can I ask a question?
Before you do, can I address one thing, Your Honor?
Okay.
In connection with the communications that occurred over the weekend, as a result of certain events last week, I informed Mr. Jackson that we would be withdrawn. And it was his understanding that I was not going to go further in the case, and therefore he was stuck with the proposition of having to communicate directly with them. I emailed him after I discovered that. He's agreed as part of this that any communications with either the board of directors or the attorneys will come through our office. We're willing to
all communications is what you've agreed to
with respect to the board of directors and attorneys, all communications. Now, I don't think that it's fair to Mr. Jackson if he wants to communicate to other association members and do that. We'll do our best to remove the members of the board of directors from that communication if that's a complaint that Mr. Johnson has. But I don't think we can stop him from communicating with other members of the association, even if it's about this litigation, because that's a factor or a matter of interest to the entire community, if for no other reason than the potential costs that will be incurred by the community in having to deal with this case. And so, as I said, we're happy to be the gatekeeper. We're happy to take care of communications, but I honestly don't think that there's a workable method with respect to other members. And the court may disagree, and if it does, I'm fine with it.
It gets to be, to me, that the main issue I have is just his client is the board of directors. The board is made up of the directors and then the members. Unless you wanted to get me some briefing on this, which I'd be glad to listen to, my gut instinct is that he really should not be communicating even to other members about the litigation. That's my gut.
We could agree to that, Your Honor, if the same holds true for the association, ICI, and the members of the board of directors, because Mr. Hearn, as counsel, wrote a several-page letter where he went through in detail items with direct respect to Mr. Jackson. And I'm not accusing Mr. Johnson of that. But the fact of the matter is, if we're going to
did he send those to all the members or just to the board?
It got posted on the.
Well, I'm the one with the most factual information on that, Judge, if I could speak to that. Mr. Hearn wrote an 8-page defamatory letter loaded with lies that was sent out to myself and every individual member dealing with the court issues and other issues. And I immediately contacted my attorney on it. He had me do a briefing on all the lies that were in it, and I sent it to him, and somehow the ball got dropped. But Mr. Hearn has repeatedly done the same thing to me that Mr. Johnson is accusing me of doing to the board. He also sent an email out to all the membership disparaging me, and we have yet to file any actions or any causes of action on that, trying to keep this thing simple to a water claim case. Now, it's also interesting that Mr. Johnson doesn't bring up to you that actual settlement documents and parts of this case have been posted on the website to disparage and to demean me to the entire membership for everybody to see. Those were not sent to my attorney. They were sent to the website for myself and the other members. Now, here is what I have concluded out of this, okay? If I was in Mr. Johnson's position, I could even do a more effective job than he has done showing you how you could relate every possible email, okay? Everything, when you deal with capricious and arbitrary, you deal with fraud, conspiracy to commit fraud, it is impossible to get any type of a message out to the membership to get my slate elected to solve the $2.5 million in increased dues.
So wait. You're going off topic here. Let me just talk
Okay.
to Mr. Johnson at this point. So, Mr. Johnson, what is the deal with these postings that Mr. Hearn, I guess he's your co-counsel?
Your Honor, Mr. Hearn represents the association and the management company and has for years. He was counsel before I got involved. I believe what Mr. Jackson and Mr. Payne were referring to was Mr. Jackson sent an email out to the entire association. I believe it was in June of last year. In fact, I think I may have even attached it to our initial motion for protection. It was a very, very, very lengthy email, and Mr. Hearn filed or sent a response to Mr. Jackson's email pointing out all the misrepresentations and issues associated with Mr. Jackson's email. I don't know.
So he was responding to Mr. Jackson.
He was responding to Mr. Jackson. I don't know what this other stuff.
So let me just say this, which is, I do think it should go both ways. I don't think that
I agree
that Mr. Hearn should be posting about Mr. Jackson if, absent further court order.
Right.
And so this should go both ways. I mean, the discussion of this lawsuit should be, should be between counsel, and counsel and their client, not to the whole world or to the entire membership. So it's good to hear a little bit of flavor on this, but I do think that at this point, do you need me to rule on something? Do you have language you want me to look at to make some kind of determination? At this point, you're just kind of arguing all about, to me, it's what is the language of the order is the key thing.
And
Judge,
Your Honor,
I've conceded to Mr. Johnson that I'm just going to disappear into the sunset. I'm not going to run for the board. There's not going to be any more emails going out. There's not going to be a peep from me. Mr. Payne and I agreed that my passion for leading the opposition to the board of directors needs to stop because I'm in this lawsuit. So in the guise of moving to a settlement and getting this thing done, there's not going to be any email from me going to anybody. There's not going to be any communication. There's not going to be nothing. I'm going to be focusing on my other businesses, and I'm giving up my first right amendments to be able to speak to the membership. I'm giving up my first right amendments to run for the board. I'm giving all of that up so that Mr. Johnson can't continue the smokescreen on what the real issue is, which is the concealment of documents, which both he, Mr. Hearn, and the board have continued to keep from this court for 2 years. So I'm going off into the sunset. You're not going to have another peep out of me. Mr. Payne and I worked all that out.
Great.
That's where I'm at.
So, Mr. Payne, so at this point, I guess, is there language you want me to look at to make any determination? Do you feel like you can work this out? I just need to get an order so that, and just so it's clear why it's important to have an order. I believe you, Mr. Jackson, that you are going to do that, but I've also had people in your exact same situation that have said they're not going to do X and then they do X. I can't really do anything about that unless there's a court order in place. And then if there's a court order and you violate the court order, then you could be subject to contempt. And that's really the biggest power I have involving these matters. And
well, the first one you have is a good order. If Mr. Payne wants to improve upon it, I'm all for that. But you already have one in place that I didn't know about. Chris, is that a good one or no?
Your Honor, I'm confident that Mr. Johnson and I, in a telephone call, can probably work out orders that we're both comfortable with, and we'll submit those by agreement, Your Honor.
I agree, Your Honor.
Okay. All right, guys. Well, thank you so much. Have a good day, and we will go from there. Thank you so much.
All right, very good.
Thank you very much, Judge. Bye-bye.
Mr. Mosley, are you still here for something? I thought you were going to drop off at 2:10. Are you just enjoying this?
Well, I understood you said wait around till 2:10, but I don't leave until I get specific authorization.
Oh, I'm so sorry.
No problem.
I didn't mean you to stay. I apologize. I was focused on other things. You could have left at 2:10. I apologize that you stayed on, and you're welcome to go. And thank you so much. And you have a great week. Okay.
Thank you, Judge. You too, and stay safe, sir.
All right. Thank you. You too. Okay, well, is our 2:30 hearing off? We've had a lot of cancellations. Let me kind of take a look at this. I'm guessing our 2:30 is off because I feel bad that guy was just sitting there. I thought I made it clear you could leave. I feel
He
bad.
was enjoying it.
Yeah, it's pretty lively, that guy. Oh, let me